Sure. That was mine for all those years.
It was so hot. It was so hot over there.
Oh, yes, really?
Yes, it was so hot, but I enjoyed it.
Yeah, I'm glad. You know,
Yes, I
one of
enjoyed
these
it.
maybe next time you can tell me more of the details.
Yes, yes, I will. Hopefully, I'll have some pictures printed out by then.
Yeah,
So that I can show you. Yeah.
Yeah, I enjoyed it. It was hot when I was there too.
Did y'all go to Jordan?
No.
Some other people I was talking to yesterday, they said they didn't go. We went to Jordan and we had an armed police officer on
Wow.
the whole leg of the trip. We were there for about 4 days. But he was on the bus with us. Like
That was an excursion, but we didn't take it.
That's what somebody else said.
Yeah.
It was nice though.
Good.
So yeah, I'll bring pictures next time.
All right. Okay, so we'll be ready to crank this one back up again. What now? Well, I think it's up to y'all to decide.
Okay, because you already signed the order. So I told him if y'all have to go out there every day, you just have to go out every day, and if he won't, then y'all have to just stack it up and see.
You're right.
Or you're gonna dismiss it, or.
Yeah, well, that would be y'all's decision. All right, so as soon as Ms. Lozano gets back, we'll continue with Mr. Anderson's cross-examination.
I'm sorry.
Look, I need it.
All right. Let's go see babies, children. The ones that are nonverbal and are happy to see you. Have a good day.
Thank you, you too.
Bye.
All right.
Bye. We'll be in touch.
Okay. Yeah, she. Yeah, I can drop these. Oh, about the oil? The vital stitches. Oh, yeah, addition.
All right, so while we're getting ready, I guess Mr. Anderson, Ms. Atkins, and Mr. Nelson, if you want to unmute.
Good morning, everyone. Can y'all hear me okay?
I can hear you fine. All right, so we'll come back on the record on 2022 L8078, the interest of Ian Nelson and Luke Nelson. And Mr. Anderson, you may proceed.
Thank you, Judge. Mr. Nelson, can you hear me okay?
Yes, sir.
Okay. In y'all's exhibit 20. Okay, you see what I'm talking about?
Yes, sir.
Okay. You flip about 7 pages in.
Okay, I'm 7 pages in.
Okay, that's kind of a, I guess, that's Facebook Messenger? Is that right?
Yes, sir.
Okay. And you asked, Crystal, what's Ian going to be doing while you're gone? You see that?
I said, what is Ian going to be doing?
While you're gone?
No, sir.
April 1st, 2022 at 9:25:56 p.m. You looking at that?
Say the time again.
It says April 1st, 2022, 9:25 p.m. This is the,
Okay, I'm on the same page now.
okay, you see what I'm talking about?
Yes, sir.
Okay. And you would agree with me, it says, what is Ian going to be doing while you're gone?
Yes, sir.
Okay. And then she replies, he'll be in school and with my parents. He can't miss days or he won't be allowed to go on an end of the year trip to Splashtown. See that?
Yes, sir.
And then she also says, about 15 seconds later, no worries, he'll have his phone so you can call whenever works. See that?
Yes, sir.
So fair to say that she notified you he has a phone and that you can call him whenever, right?
No, sir.
That's not what it says.
Ian didn't have his phone. Luke had his phone.
Okay. So were y'all talking about Luke or Ian?
I don't know.
Okay. Well, either way, your children had their own phone that you could have called whenever. That's what she
Objection,
told
Your
you.
Honor. Misstates evidence.
Objection's overruled.
Correct?
I'm sorry. Can you say it again?
One of your children that was staying, which one stayed and went to school when the other one went with your mom?
Ian stayed and went to school.
Okay, so Ian had his phone and you could have called him whenever, correct?
No, sir.
That's what y'all talked about. Isn't that the case?
That was my understanding of what we talked about.
Okay.
But Luke had.
What was said is what's in this Facebook message, correct?
Correct.
Okay. So if Ian was the one that stayed, that's who y'all were referring to, correct?
Yes.
Okay. Now, would you agree with me that y'all's order that we're here on happened in it was signed October of 2019. Would you agree with me?
Yes, sir.
Judge, we'd ask that the court take judicial notice, that the order was signed in 2019, October 2019.
Is that,
Your Honor, my only objection to that is you specify which order. There's two of them.
and is this gonna be the order from Arizona?
So the decree of dissolution of marriage and an incorporated parenting plan in cause number D 201-91999, that it was signed on October 29th, 2019. You would, and then the child support order in the same cause number was also signed on October 29th, 2019.
I'll take judicial notice of the divorce order and the child support order.
Did you say you take judicial notice of both, Judge?
I will.
Okay, thank you. So you would agree with me that 3 years has not elapsed since the signing of that order, correct, sir?
Correct.
Okay. Of the child support order, right?
Correct.
And you would agree with me that you're still in the same job you were in when that one was signed, correct?
No.
You were not in the military in 2019?
Yes, but not same job.
Okay, were you in the Navy?
Yes.
Okay. What rank were you, sir?
E6.
What rank are you now, sir?
E6.
So you're still the same rank. And you would agree with me that deployments are something that happen regularly, correct?
Correct.
And that kind of stuff is anticipated in the job, correct?
Correct.
Sir, on your exhibit A that y'all filed for the notice of registration of a foreign order, you would agree with me that it's checked that on the first page where it says the parties have agreed to a division of community property and debt as evidenced by their signatures on the bottom of the document. You would agree that that's what it says, correct?
Which exhibit again?
Objection, Your Honor, to my opposing counsel asking questions regarding a document that's not in evidence.
Just, I guess, get it identified first.
Sir? Judge, if you'll give me 1 second. Yeah. Sir, are you familiar with this document that was filed by your attorney in this case and which was agreed for the court to sign the registration of a foreign order? Are you familiar with this document, Exhibit A?
Your
I don't see a
Honor,
document yet.
I have no idea what my opposing counsel's talking about either. I don't understand the question.
So has that Exhibit A, was that forwarded to Miss Atkins?
This is what they filed to register this foreign order in this court. This is what we agreed that the court was acquiring as the foreign order, Judge.
Okay, and I signed an order this morning about the foreign order. So I guess just what's the question about registering the foreign order?
So this should be an order of this court now, Judge.
Okay, so the order from Arizona has been registered here in Austin County.
Which is this order right here, Judge.
Okay, so is that the divorce decree or the child support order?
This starts the decree of divorce. Yes, Judge.
Okay, so I think Ms. Atkins, he's talking about the divorce decree from Arizona.
Okay, that clears, I wasn't sure what he was talking about, Your Honor, and I didn't receive any documents. I didn't receive any exhibits from my opposing counsel for this hearing at all, so I was confused. So he's talking about the final decree. Okay.
So is there still an objection? I'm just going to ask the court to take judicial notice of it.
And
And
I've taken judicial notice of the decree, the child support, I've signed an order. So let's go.
okay, so sir, you see here how the parties agreed to the divorce decree, correct?
All I see up on my screen is a list of PDFs with titles.
Sorry, Judge. Do you see you don't see the decree?
I don't see the decree either.
Okay, Judge, I'm sorry. Let me see if I can.
I'm looking at it in the file. I don't see it on the monitor.
Okay, sorry, is that better?
Yes,
Okay. All right, my apologies. I'm not real good at this screen share deal. You see here where it says the parties have agreed?
yes,
So y'all did agree then to the decree of dissolution of marriage with children, correct?
Your Honor, I have to object that misstates what the document itself says.
Okay, then you can cross-examine him on this, but we really need to get moving. I mean, to go over this again, we were told this hearing would take 2 hours. We're now into about 5.5 hours and we're still on the first witness. So unless there is really a critical objection, we need to get moving because we're not going to finish today. I mean, and I don't know when we're going to proceed. So keep going, Mr. Anderson.
Yes, sir, Judge. And this is your signature too, sir, correct?
correct.
Okay, so not only did you agree to the decree of dissolution of marriage with children, you also signed it, right?
Correct.
And you knew when you made these agreements that there was going to be child support and visitation in the decree, correct?
Correct.
Okay. So the child support amounts that are there, that was agreed upon along with the visitation at the time, correct?
Correct.
Pass the witness, Judge.
All right, Ms. Akins.
I will make this quick, Your Honor. Mr. Nelson, have you had more than 14 days of possession of your children since the divorce decree was signed?
Yes,
And at any time, have you agreed that you would only speak to your children 1 day a week?
No,
Okay. And at the time that your final decree of divorce was signed, where was Miss Nelson living? What state?
Arizona.
And were you also living in Arizona at that time?
Yes,
And since then, you no longer live in Arizona, correct?
yes, ma'am.
And how long has it been since you've lived in Arizona?
Since June of 2020.
Okay. And sir, isn't it true that you didn't agree to the parenting plan that was attached to your final decree of divorce?
Objection already asked and answered, Judge.
Objection overruled.
Sir, I'm going to show you a copy of the parenting plan up on the screen. And I'm going to ask you to look at this portion of the parenting plan that's right there at the beginning.
Mm.
Can you read for the court what that part says?
That's starting at the very top.
Mm-hmm.
This parenting plan is submitted by only one parent without the consent or signature of the other parent. The submitting parent believes that this proposed plan is in the best interest of the children. Parent submitting. And
And is that
this
your
one-
signature, sir?
That is not my signature.
Okay. And so does that change your testimony whether or not you agreed to that parenting plan?
Yes, ma'am.
Your Honor, I'm going to pass the witness.
Mr. Anderson?
Yeah, briefly, Judge. That signature that your counsel just showed you, that was from October 28th of 2019, correct?
I would have to see it again.
Counsel, do you mind pulling back up, or do you want me to go through the?
No, I don't mind. I don't mind pulling it back up. Just bear with me. I'd close it so I'm not on the same page anymore.
Okay. You see that date, sir?
Yes, sir.
That was 10/28 of 19, correct?
Yes, sir.
And then you signed on 10/29 of 19, correct? It would be at the beginning. Page 1. Or go down a few more. Keep going. Okay, so see, you signed the document the day after, correct?
Yes, sir.
And so you would have seen all these documents before signing that the very next day, correct?
Correct.
That's what.
All right, Ms.
No
Atkins?
further questions for this witness, Your
I
Honor.
was gonna say, before you remove that from the screen, I don't know, can you get it back up?
Yes, not a problem. Hold on. There you go, Your Honor.
Okay, so go to page 11.
Yeah, that's somebody else's stuff, Judge, that was accidentally put in their file.
Yeah, I think the court in Arizona messed up, Your Honor, when they combined the two into the same document.
Okay, well, can you find the so I'm trying to find, I think it's the divorce, find the divorce decree.
I have the divorce decree, Your Honor. Is there a
Okay.
particular page you're looking for?
Page 11. It doesn't look like, it doesn't look like the page I'm looking at. Okay, I guess the document that I'm looking at, maybe it's the parenting plan.
That might make more sense, Your Honor. Hold on, I'll bring you to the parenting plan. That is the parenting plan.
Okay, so then go to page 11.
Is that it?
I think that's page 12.
Oop, that is page 12. You are correct. There you go, Your Honor.
Okay, so stop right there. Okay, so to Mr. Nelson, at the very bottom of the parenting plan, there's a section called telephone access and no boxes are checked. So when did you make an agreement with Ms. Nelson about telephone access with the children?
I don't believe we ever reached an agreement on telephone access as far as the frequency of communication between us.
Okay, I thought there was an agreement that you talked on Saturdays.
So yes,
So what's that agreement?
that we would talk on Saturdays at 7 p.m. Central Time.
For how long?
Anywhere between 15 minutes to an hour, depending on the communications devices and if they were charged or not.
And who initiates the call?
Usually it will be me. I will send a message requesting to speak with the children.
Okay, so you send a text to Miss Crystal Nelson.
Yes, sir.
And then and then after the text, you communicate. Is it by telephone or FaceTime?
Yes, sir.
Which one?
Oh, usually Facebook Messenger.
Again, I'm electronically handicapped, but I think of Facebook Messenger as being a written communication. The one I have, I can send written messages to people. So do you have a Facebook Messenger where you can speak?
Yes, sir. There's a video option and a call option on Facebook Messenger, and we would use the video method.
All right, so any other questions to Mr. Martin Nelson?
No, Your Honor.
All
I don't
right.
believe I have any, Judge.
Okay, so Miss Atkins, who's your next?
Your Honor, I'd like to call Miss Crystal Nelson.
All right,
And can I stop sharing the screen, Your Honor?
yes.
And Judge, I'm sorry, can you give me 2 seconds? I'm gonna run my computer cord.
Okay. Yeah.
Sorry, I'm back, Judge, go ahead.
All right, so Miss Atkins, you may proceed.
Thank you, Your Honor. And would you please state your legal name for the court?
Crystal Lynn Nelson.
Okay. And ma'am, you are the counter petitioner in this case, correct?
Yes, ma'am.
You are also the mother of Ian and Luke Nelson, correct?
Yes, ma'am.
And Martin Nelson is your ex-husband, correct?
Yes, ma'am.
Ma'am, would you agree that it is important for children to have a close relationship with both of their parents?
Absolutely. Yes, ma'am.
And ma'am, you're not opposed to Mr. Nelson having electronic communication with his children, correct?
No, ma'am.
And ma'am, would you agree that it would be beneficial not only to your co-parenting relationship with Mr. Nelson, but also to your children for there to be set days and times for Mr. Nelson to communicate with your children
Yes, ma'am.
electronically? Okay. And ma'am, are you opposed to the dates and times that are set out in Mr. Nelson's request for relief?
Would you state for us those for the record, please?
Sure. They are Tuesdays, Fridays, and Saturdays between 6 and 8 o'clock.
Yes, ma'am.
Okay. Are you opposed to all of those days or just some of them?
Friday?
So you're only opposed to Friday, is that correct?
Yes, ma'am.
Okay. And what is the problem with Friday between 6 and 8 for Mr. Nelson to communicate with his children?
Being that we do extracurricular activities on Fridays and Saturday evenings, it would be nice to have uninterrupted time with the children to conduct their extracurricular activities.
Okay, and what extracurricular activity do the children have currently on Friday nights between 6 and 8?
We are currently working on building a motor with their grandfather. We also have a large garden area that we're working on together as a family. We do board games and things like that.
So you have family time, but you don't necessarily have any scheduled extracurricular activities, correct?
We generally are scheduled with my father to work on the motor with him, but it's not a registered event, no.
And would you be able to reschedule for that Friday afternoon to some other time?
Sunday evenings don't work because we're all getting ready for work Monday morning,
Yes,
and then Saturday.
non-responsive.
Would you rephrase the question, please?
Ma'am, is it possible to reschedule to allow your children to be able to communicate with their father between 6 and 8 on Fridays? To
No, ma'am.
reschedule the activities?
No, ma'am.
Okay. All right. And ma'am, do you think that it's more important for your children to work with their grandfather on building a motor than being able to communicate with their father?
Can you rephrase the question?
Do you believe that it's more important for your children to build a motor with your father than it is for them to be able to communicate with Mr. Nelson?
Right, that was a repeat. Can you rephrase that question for me?
Yes, what part of it don't you understand?
No,
I didn't understand your answer.
no, I don't believe it's more important for them to spend time with their grandfather as opposed to their father.
Okay. So ma'am, you would agree that the court then should allow Mr. Nelson to have communication with his children on Fridays between 6 and 8 then?
No, ma'am.
All right. And ma'am, you would agree that you have asked this court to appoint both you and Mr. Nelson as joint managing conservators, correct?
Yes, ma'am.
Okay. And ma'am, you would agree that Mr. Nelson should have periods of possession and access with his children, correct?
Yes, ma'am.
And ma'am, would you agree with me when I would, with the statement that you don't particularly enjoy having to communicate with Mr. Nelson?
Yes, ma'am.
And would you agree that it would be in your children's best interest for you to not have to communicate with Mr. Nelson any more than necessary in order to co-parent with him?
Yes, ma'am.
And so would you agree that it's in your children's best interest to have a set period of possession schedule for Mr. Nelson?
Yes, ma'am.
And ma'am, are you opposed to Mr. Nelson having possession of your children under a standard possession order?
Yes, ma'am.
Okay. Ma'am, what period of possessions do you think Mr. Nelson should have?
May I confirm with my attorney, please?
No, I want to know your answer. What do you think Mr. Nelson should have for periods of possession?
We generally, so what we previously agreed upon was doing,
Objection, non-responsive.
Objection sustained. Just what do you think is in the best interest of the kids?
every other holiday, a year, by like 1 year Christmas, the next year we switch over to the other one. The same for all holidays, except for Mother's Day and Father's Day. 14 days in the summer. And then I wouldn't be opposed to his mother having once a quarter, a weekend, once a quarter.
So you don't want Mr. Nelson to be able to have any type of weekend periods of possession, just holidays and summer, is what you're testifying to?
Not in Japan.
Okay, so your opinion on where he should be able to, your opinion on what periods of possession he should have depends on where he is currently located.
Yes.
Okay. So will you tell the court what additional periods of possession he should have if he's stationed stateside then?
If he was stationed stateside, I would be comfortable with him having them once a weekend, the weekend once a month. And again, with the alternating holidays and 14 days in the summer.
But you would still be opposed to Mr. Nelson having a standard possession, correct?
Objection misstates the law. A standard possession order in Texas can still be 1 week in a month that he chooses.
It would also, I think, depend if they're within 100 miles of each other. So there's a lot of variables here.
Your Honor, I'll rephrase the question. Ma'am, you would still be opposed to, would you still be opposed to Mr. Nelson having periods of extended summer possession as is stated in a standard possession order?
Within the contiguous United States, no.
Okay.
Or whatever it's called.
And ma'am, are you opposed to your children having passports?
Yes, ma'am.
Okay. Are you opposed to your children traveling outside of the United States?
Any country that's higher than a level 1 on the DOJ travel list, yes.
Okay. Ma'am, do you know what the current travel COVID levels are for the United States currently?
No, I do not.
Okay. And ma'am, would you be surprised to learn that the COVID risk level for the United States is the same as in Japan, according to the CDC?
Speculation, Judge. Facts not in evidence.
She can, if she knows, she knows. If she doesn't know, then she says she doesn't know.
I wouldn't know.
Okay. And ma'am, would that change your opinion on whether or not you would be concerned about your children traveling to Japan?
No, ma'am.
Okay. And so, ma'am, I'm going to ask you, other than the COVID-19 concerns, what other concerns do you have with your children being able to travel to Japan?
So there's the flight risk. It's put into a high intensity situation whenever it comes to being able to handle the COVID on the plane. They're at a higher risk of catching COVID on the airplane. My son is very young, and I don't think he would be comfortable on a flight for that long. The state of the current war in Ukraine between Russia, China, all of that, Japan is currently an active, they're kind of bulking up their defenses because China is going after Taiwan, or they're getting closer to talking about going after Taiwan. I know there are active protests.
Objection, Your
near the
Honor,
base.
as to personal knowledge.
Judge, she's answering.
Yeah, I think she was just I can't tell you the exact words, but I think you were just asking why she felt that way. So she's explaining. So objections overruled.
Yeah. There are protests near the base. The DoD gives out warnings for the civilians outside of the base on Japan. There's a lot of conflict in the area, just in general, between the Japanese and the Americans. It's just really doesn't feel like a safe place for me to allow my children to go. Especially because getting them out, if something does happen, would be very difficult, and I wouldn't want them to be stuck there in an uncomfortable and unsafe situation without someone, without myself or someone that they're used to being around there.
Okay. Well, ma'am, let's take these one at a time. You said that you are concerned about the increased risk of your children contracting COVID when they're on a plane, correct?
Yes, ma'am.
But your children have been on a plane multiple times since COVID-19 first came into existence in March of 2020, correct?
Very short flights. Yes.
Okay. And ma'am, to your knowledge, does the length of the flight affect the possibility of them being exposed, to your personal knowledge?
I can only speculate.
Okay, so you have no personal knowledge that the length of the flight affects the risk of your children contracting COVID, correct?
I can imagine that it would, but I can't give you any scientific evidence proving that, no.
Okay. And ma'am, you don't know what what procedures are in place on the base where Mr. Nelson is currently stationed regarding if there is any type of emergency, correct?
Any of the procedures that they have on the other side of the continent at this point to get my children all the way across the globe? No, I'm not aware of those.
Okay. And ma'am, other than what you have, do you have any personal knowledge of that there is any type of unsafe situation surrounding the base currently in Japan?
At this current time? No, but I do know that there have been warnings issued because there are.
Objection, Your Honor, non-responsive after she said no.
Objection sustained.
Ma'am, are your children currently vaccinated for COVID-19?
No, ma'am.
And are you concerned about your children contracting COVID-19?
Yes, ma'am.
Okay, then why haven't you vaccinated them?
Objection. That goes to her belief as to why she doesn't.
Well, then she can incorporate that into her answer if she'd like.
Personal and religious beliefs.
Okay. And ma'am, you stated previously you're not opposed to Miss Elizabeth Murphy, Mr. Nelson's mother, exercising periods of possession with the children while he's stationed overseas, correct?
Yes, ma'am.
Okay, and how frequently do you believe her exercising those periods of possession would be in your children's best interest?
Judge, objection. Asked and answered. She answered that earlier, Judge.
Okay, well, objection overruled. Go ahead and answer again.
1 weekend per quarter.
Okay. And would that be a pickup on Friday and drop off on Sunday or Monday, or how do you foresee that looking, ma'am?
Whatever would be most convenient for her.
Okay. Ma'am, are you opposed to communicating with Mr. Nelson via our family wizard?
No, ma'am.
Okay. And ma'am, do you currently monitor all of the children's communications with Mr. Nelson?
Yes, ma'am.
Okay. And do you believe that that's in the children's best interest?
Yes, ma'am.
Okay. Do you believe that Mr. Nelson does the same thing to all of your communications?
Yes, ma'am.
Ma'am, do you believe that monitoring your children's communications with their father allows them to have open and honest communications with Mr. Nelson?
Yes, ma'am.
You don't believe that your children may not want to say something to Mr. Nelson because it could possibly hurt your feelings?
Objection, speculation as to what the kids think.
Objection sustained.
Ma'am, you currently share legal decision-making abilities with Mr. Nelson, correct?
Yes, ma'am.
And do you have any problem continuing doing so?
No, ma'am.
And you believed at the time of your divorce that that was in your children's best interest, correct?
Yes, ma'am.
And you still believe that, correct?
Yes, ma'am.
And ma'am, one of the things that Mr. Nelson has asked for in his request for relief was that the children's residence for the purposes of temporary orders be restricted to a certain geographic restriction. Do you understand that?
I'm sorry, can you repeat that for me?
Do you understand that Mr. Nelson has asked that the residence of the children be restricted to a specific geographic area?
Yes, ma'am.
Ma'am, do you have any intention on relocating from Austin County, Texas during this litigation?
No, ma'am.
And do you believe that that would be in your children's best interest for during this litigation, you'd have to continue residing within Austin County, Texas?
Yes, ma'am.
And ma'am, do you believe that you and Mr. Nelson should have to agree before your children would have to receive any medical, dental, or surgical treatment that involves an invasive procedure that's non-emergency?
Yes, ma'am.
And ma'am, would you agree that both you and Mr. Nelson should have the right to seek, after consulting with the other parent, obviously, psychiatric or psychological treatment for your children?
Yes, ma'am.
And ma'am, would you agree that you and Mr. Nelson need to continue both sharing, subject to an agreement between the two of you, the right to make educational decisions?
Yes, ma'am.
Ma'am, is there anywhere on this planet that you would feel comfortable with your children traveling outside of the United States currently?
No, ma'am.
Ma'am, do you have any problem with exchanging the children with Mr. Nelson at the airport closest to where your children reside?
No, ma'am.
Ma'am, do you have any, in your final decree of divorce, the court has specifically allocated that the cost for the travel for the children be allocated 39% to you and 61% to Mr. Nelson, correct?
Yes, ma'am.
And you are not asking the court today, you don't have any relief on file, asking the court to change that arrangement, correct?
Correct.
And ma'am, are you opposed to Mr. Nelson being able to select a 14-day period of possession during the Christmas holidays with the children?
No, ma'am.
So you're not opposed to Mr. Nelson's request that when he doesn't live within the continental United States, that he gets to request that 14-day period of possession during the Christmas holidays?
No, ma'am.
Your Honor, I'm going to pass the witness.
Mr. Anderson?
Thank you, Judge. Okay, Ms. Nelson, let's talk a little bit about let's start with the phone calls, right? There was a lot of discussion about that. you don't think that Mr. Nelson's communications with his sons is less important than doing other activities, correct?
Objection
In
or
fact,
leading.
Objection overruled.
In fact, is it fair to say that it's more important?
Yes, sir.
And you're not opposed to him even talking to the children 3 days during a week, are you?
Nelson's talking away from the
Okay.
computer or something. that I
Okay,
can't
and
quite
so
hear.
we need to get Ms. Nelson to speak into the microphone.
You're just requesting the court to do it a different day other than Friday, correct?
Yes, sir.
So,
Okay, I couldn't hear her answer.
okay, let me try something else.
You can talk louder.
Mr. Anderson's going to try to sign in from his phone.
I'm gonna see if it'll work better for my phone if she's the only one.
One of the lines have to be muted if they're right next to each other. Or else it's not going to be heard.
Is that better, Judge?
We'll find out when we hear her answer.
Okay. Miss Nelson, can you hear me?
Yes, sir.
So you're not asking the court to not give him 3 days to communicate with his children from 6 to 8, are you?
No, sir.
Objection, Your Honor, leading.
We just, for time, I gotta speed this up, so I'm gonna overrule the objection, overrule the leading objections. You can cross-examine if you want.
Are you just asking the court to, if the court granted a Tuesday, Thursday, Saturday, would you be okay with that?
Yes, sir.
Okay. Now, and you've allowed the kids to talk to him whenever he calls, correct?
Yes, sir.
As long as there wasn't something pressing going on at the time.
Yes, sir.
Now, he talks about interference with a phone call. Can you explain what was really happening with these, that he's calling interfering with a phone call?
Those would be extended periods of phone conversation that went into either a dinner time or another scheduled event that we have with the children.
So it was just keeping him on a schedule?
Yes, sir.
Okay, so he was talking to the kids for how long, do you know?
His conversations range anywhere between 15 minutes to about an hour and a half.
Okay. And he plays video games with the kids, correct?
Yes, sir.
So are you sitting there watching them play video games the whole time?
No, sir.
So they communicate playing video games for what, sometimes an hour without you being there?
That will,
Objection,
yes,
Your
sir.
Honor, leading.
Objection's overruled.
And lacks personal knowledge.
Ma'am, if Mr. Nelson was in the United States, would you have any problem with the SPO where he wanted to have them first, third, and fifth weekend and he came to get them, where he could have that?
No, sir.
Would you, and if he had 42 days in the summer, would you be okay with that?
Yes, sir.
It's being in Japan, in a country that even the DOD says reconsider travel, that's what it's causing you problems?
Yes, sir.
Objection, Your Honor, assumes facts not in evidence.
And she's testified why she's hesitant, so objections overruled.
And ma'am, y'all agreed to what was in the divorce decree from Arizona, correct?
Yes, ma'am. I'm sorry, yes, sir.
And you heard Mr. Nelson's testimony about nothing has changed as far as his rank and job and whatnot as far as child support goes, correct?
Yes, sir.
And he's been aware of that child support amount and has been paying it, correct?
Yes, sir.
Okay. Now, if his mom was to exercise visitation, correct? You understand what I'm saying?
Yes, sir.
She's not a party to this lawsuit, right?
Yes, sir.
And so if she was to have them and you think it's important that they go see her, is the one weekend a month, like on a long weekend every quarter, do you think that's in the best interest of your children along with 2 weeks in the summer?
Yes, sir.
Okay. And the kids are in school, are they not?
Yes, sir.
And so if they're in school, unless it's on a long holiday weekend, that would make it difficult for her to bring them back Monday, correct?
Yes, sir.
But if she did it on a weekend when they're in school that wasn't a holiday, it'd have to be Friday at 6 p.m. to Sunday at 6 p.m., correct?
Yes, sir.
And when's the last time these boys have even gone to see their dad?
It would be when they went to Virginia, or no, they went to Arkansas to see him over a Christmas break, the winter break.
Okay, and when was that? You know what year?
I don't remember which year.
Was it last year?
I don't remember. I'm drawing a blank off the top of my head.
And if Mr. Nelson was to come here and want visitation here, instead of having the kids go to Japan, would you be okay with him having the winter break and summer break here?
Yes, sir.
You'd be okay with that?
Yes, sir.
So is it correct in saying you're not trying to keep these kids away? You just don't want them to go overseas?
Right. Correct.
And that's what y'all agreed to in the possession order as well, correct?
Yes, sir.
Objection, Your Honor, assumes facts not in evidence.
Judge, the court's already taken judicial notice of the decree with the possession and access in it.
Okay, so I'll consider the decree and what it says.
Thank you, Judge. So are you asking the court to deny their request to send the children to Japan during the summer because you don't feel that it's in the best interest of your kids?
Yes, sir.
And are you asking the court to deny their request for a decrease in child support because it doesn't uphold the law, first of all, and the fact that they want to take a flight that potentially could only happen 1 to 2 times per year for the next 2 years, and then it would be something else, is not really in the best interest of these kids, is it?
No, sir. It's not in their best interest.
It doesn't conform to what you can use for the guideline, does it?
Objection, Your Honor, calls for a legal conclusion.
Objections overruled.
You can answer, Ms. Nelson.
Yes, sir.
Pass the witness, Judge.
Ms. Atkins?
Ms. Nelson, what do you do for a living?
I currently work as a paralegal or an office manager at a law firm.
Okay, and does that law firm practice family law?
Yes, ma'am.
And that law firm that you work at is actually Mr. Anderson's law firm, correct?
Yes, ma'am.
And so are you aware of how child support is calculated?
Vaguely.
Okay. And ma'am, have you calculated what Mr. Nelson's child support would be pursuant to guideline in the state of Texas?
No, ma'am.
So you're not aware of whether or not the child support calculation that was submitted to the court marked as exhibit number 3 is accurate or not?
I'd have to look at exhibit number 3.
Okay. I will put it up on the, I'll put it up for you, ma'am. All right. Do you see that, ma'am?
Yes, ma'am.
Okay. And based off of now that you've seen it, is it accurate?
I do not believe that document is accurate.
Okay. What's wrong with it?
I'd have to look at it.
Well, ma'am, I have it up on the screen
Thank
for
you.
you. Ma'am, are you looking at something else in front of you?
The same exhibit that you have up on the screen
Okay.
so that I can see the top portion of it. I don't believe that his monthly gross wages were input correctly.
And ma'am, do you know what amount do you believe should be put there?
I wouldn't be able to give you, it would be speculation without having able to
And
look at
ma'am-
everything.
How much is Mr. Nelson's child support currently?
1664 and change.
Okay. And so, ma'am, you don't know if whether or not the standard Texas child support guideline amount would be less than the amount that he's currently ordered to pay or not, correct?
Correct.
And ma'am, you've stated that you always allow Mr. Nelson to be able to communicate with his children whenever he's asked for it, unless the children were busy doing something else, correct?
Correct.
Ma'am, I'm going to show you what's been marked as petitioner's exhibit 46. Do you recognize this exchange between you and Mr. Nelson?
Yes, sir. Yes, ma'am.
Okay. And so would you agree that on March 28th of 2021, that Mr. Nelson had sent a message to one of your children asking if he was available to talk, and you responded with, you had visitation yesterday?
Yes, ma'am.
Ma'am, would you agree that that is not allowing Mr. Nelson to have visitation with the children, or excuse me, communication with the children whenever he asks for it?
Not without the complete conversation.
Ma'am, are you asserting that that's not the complete conversation on March 28th of 2021?
Yes, ma'am.
Okay. Do you have what you are asserting is the complete conversation?
Not with me. No, ma'am.
Okay, so ma'am, how do you know that that's not the complete conversation that took place on that day?
Because there are generally multiple forms of communication that we utilize. And whenever we do talk, we generally don't talk in 1 or 2 sentences.
Okay. So are you asserting that there was a different form of communication that took place that day,
It's possible.
but you don't know?
No, ma'am.
Your Honor, I pass the witness.
Mr. Anderson?
Yes, Judge, briefly. Ms. Nelson, you and Mr. Nelson have previously testified that the order from Arizona was agreed to by the parties, correct?
Yes, sir.
And y'all agreed to 1664, correct?
Yes, sir.
as child support?
Yes, sir.
And was that agreement based on the fact that you had also agreed to incur some of the travel costs if there was any travel around the US?
No, sir.
No? So the agreement with the 61% and 39%, that was all part of the agreement, correct?
Objection,
sir.
Your Honor, asked and answered.
Objection overruled.
So all the things that were in the order were took into contemplation when coming up with the 1664, correct?
Yes, sir.
Okay. So it didn't just go off of his guideline for Arizona, it went off an agreement, did it not?
I'm sorry. It,
The
um,
1664 went off an agreement, did it not?
yes, sir.
Okay. And had y'all not agreed to that amount, there wouldn't have been an agreement for the 61% and 39%, would there?
Objection, Your Honor, assumes facts not in evidence.
No, sir.
Pass the witness.
Atkins.
Your Honor, I don't have any further questions for this witness.
All right. So Ms. Atkins, anybody else?
No, Your Honor, at this point, I'm going to rest. I've taken up enough of the court's time at this moment.
Okay, Mr. Anderson.
Judge, I'm just going to come down and that way I can do my closing from the computer where everything else is.
So no other witnesses?
No other witnesses.
No, Your Honor.
Okay, so as soon as he gets here, and Ms. Atkins, Ms. Atkins, you can do your closing.
Thank you, Your Honor. Your Honor, we would ask the court grant the request for relief that is contained within Mr. Nelson's Exhibit 1 that's been offered into evidence. As you heard the testimony of Mr. Nelson, that he believes that this is in the best interest of the children. A large portion of this, Your Honor, I believe is also agreed upon by Ms. Nelson in it. And the parts that are not agreed upon, you have heard testimony on from Mr. Nelson as to why it would be in the best interest of the children. You've heard evidence as to the cost of the flights, as well as the material and substantial change in circumstance of not only Mr. Nelson, but of Ms. Nelson and of the children since then. Obviously, the cost of the flights themselves is significant, Your Honor, even if it's just for Mr. Nelson to have to travel to the United States in order to be able to exercise his periods of possession with the children, Your Honor. As well as I believe that you've heard testimony, and I think that both parties would agree that it's in the children's best interest for this court to issue orders regarding electronic communication, as well as issue orders for Mr. Nelson to have specific periods of possession to be able to pick up and exchange the children at the airport, as well as that Ms. Nelson has testified that she's not asking the court to change who is going to be responsible for what portion of the travel costs themselves for the children in this situation, Your Honor. As far as whether or not the children should be allowed to travel to Japan, Your Honor, while I respect the concerns of Ms. Nelson, all of her concerns are speculative. There is no current pending threat that has been issued in this situation. You've heard the testimony that even the CDC, the level for COVID concerns are in fact the same in the United States as they are in Japan.
Objections overruled.
Your Honor, you've heard testimony from Ms. Nelson that the children have traveled on planes since COVID first came into existence, and that to her knowledge, there is no additional risk for the children to be able to travel internationally from gaining COVID by being on a plane, Your Honor, in this situation. And that we would ask the court to allow Mr. Nelson to be able to have his extended summer possession and other periods of extended possession that he can exercise, to allow him to be able to take his children with him to where he lives in Japan, and allow those children to be able to have one of the few benefits I think exist for a child that has a military service member as a parent. There are a lot of downsides to it, and the availability of the parent to be able to spend time with them, especially in this situation and their deployment overseas and being stationed overseas. But one of the benefits of children that have military service members as parents is the ability to experience other cultures and other countries. And we would ask that the court allow those children to be able to do that and to be able to have a close bond and more periods of possession with Mr. Nelson while he's currently stationed in Japan, Your Honor. And if he gets stationed somewhere else in the future after June of 2014 in a foreign country, to allow him to be able to visit with his children for extended periods of time, because he doesn't have the leave to be able to not bring his children to him in this situation, Your Honor. And I would ask the court to grant the relief as we have requested in this situation. Thank you.
Mr. Anderson?
Thank you, Judge. Judge, we would ask that you deny their request to have the kids go to a foreign country at this time in the heart of where all these conflicts are going on, where bombings are mere hundreds of miles away. There's defenses being put up to prep for attacks, and to where COVID is running rampant, where it essentially started over there in Asia. So even the DOD doesn't think it's a good time to travel. They put it on there as a level 3 for a reason: reconsider travel. And yet Mr. Nelson thinks it's okay to have his young kids come over there. Now, I get it. He's in the military and he can shake his head all day long, but he got deployed there. He didn't have a choice. He has a choice to not expose his kids to COVID. It blows my mind that in a time like this, where he could take 14 days off and fly in and be with his kids here in the United States, where they're safe, where he knows they're not going to be harmed, he could do that. And Miss Nelson's not opposed to that. She wants him to see his kids in a safe environment. Now, where they're going to be exposed to COVID, or the possibility of being stranded there while he gets called up to man on a ship while attacks are made on Japan, it's too risky to put these kids in harm's way when all he has to do is fly here and visit them here. He has family in Arkansas, stay there. Now, Miss Nelson is not opposed to his mom having the kids once a quarter and 2 weeks in the summer if they're going to be here. That's fine. She's not saying Mr. Nelson shouldn't see his kids. She's just saying they shouldn't travel overseas. And the opposing counsel's stance that her child support should be reduced by $8,000 to $12,000 just because that's what travel costs are is absolutely ridiculous. The guideline doesn't provide for it. And in actuality, the court shouldn't change it at all. They had an agreement. There's no material and substantial change. It hasn't been within 3 years. So the court shouldn't make a decision on it at all. They should deny their requested hold. The telephonic use, she hasn't said she wants him not to have it. Just Tuesday, Thursday, and Saturday. Why is that? Why does it have to be Friday and Saturday? Out of the weekend, there's 2 days, and he wants to consume both of them. Why not a Thursday? That just seems more reasonable. Tuesday, Thursday, and Saturday. He gets a couple days to talk to his kids. She's not opposed to any of that. The joint rights and duties, they should be joint like they were in the Arizona order. Joint, and then if they can't agree, mother has the final say. They talk about it, they come up. She's the one here with them. She's the one that does their schooling day in and day out, while Mr. Nelson's over in Japan dealing with that. She should have the final say after consulting with them. And she has no problem with that. So Judge, we would just request that you deny their request for a decrease in child support. If he comes here, he can have the kids as long as 30, 42 days, whatever it is. They can go to his mom's for 2 weeks and one long weekend every quarter. And that he be given telephonic access Tuesday, Thursday, and Saturday from 6 to 8. And it doesn't even have to be restricted to 15 minutes. It can be a little longer if they're playing a video game together. I don't think my client cares about that. It's just make it on a time that's reasonable for everybody, not just what works for only Mr. Nelson. That's all that Miss Atkins is requesting here. It's got to be what Mr. Nelson wants and nobody else. So that's what we would ask, Judge.
Atkins, anything else?
No, Your Honor.
Okay. All right. So I'm going to read some temporary orders in the record and just want to emphasize to both parents that this is a temporary order. This is not final. Unless they agree to something, we'll come back and have a bigger trial to talk about a final. So Ms. Atkins, since you were the petitioner, I'll have you prepare the temporary orders. About how long will you need to get an order put together?
Your Honor, can I have entry at least 2 weeks out?
Okay, how about it's like July 11th?
Is it by submission or appearance, Your Honor?
I'm assuming that both of you will sign off, and so it'll just be by submission.
Okay. If it's by submission, then that won't be an issue, Your Honor.
Okay.
9 a.m. submission time?
Yes. So again, have Ms. Atkins prepare the temporary orders with an entry date by submission on July 11th at 9 o'clock. All right. So again, for these temporary orders, nothing is final yet. We'll appoint the parties as joint managing conservators of the children. At this time, in a temporary order, I'm not going to change the child support, but we'll consider that at the final. As far as possession and access, for visitation inside the United States, this visitation can be exercised by Elizabeth Murphy in Arkansas or in Texas, whichever she prefers. But this will be Mr. Martin Nelson's period of possession. But again, it can be exercised by Elizabeth Murphy if Mr. Nelson is not able to do it. So first, and again, this is not going to be, I know I've said this several times, this is not the final thing. This is just now until we get to a final. So be 14 days in the summer. If we have everybody here, we can either talk about days now, or if the attorneys think they can agree to something, but I want the specific times put in the order. So Mr. Nelson, again, will have 14 continuous days of possession this summer of 2022. It'll be sometime between now and August 12th. So he'll need to designate those 14 days. And if he is unable to take possession of the children, then Miss Elizabeth Murphy can take possession of the children during that 14-day period. Be up to either Mr. Nelson or Miss Murphy to pick up and return the children. If the children are leaving Texas, then a week before the children are picked up, either Mr. Nelson or Miss Murphy needs to confirm with a text the flight information of when they're flying and what time they'll be picked up at the residence of Crystal Nelson. She'll also have some extended weekends, and put these days in the order. If the parties can agree to different times during the year, that's fine. But if they can't, then it would be including the Labor Day weekend in September, Martin Luther King holiday in January, the time to include spring break period, depending on the school schedule, and Memorial Day. Also, Mr. Nelson be able to get the Christmas holidays exercised in the United States, how that's set out in the family code. And again, if he can't pick the children up, then Elizabeth Murphy can pick them up. Okay, so for, again, temporary orders at this time, I'm not going to rule on travel to Japan. I'll leave that for the final. As far as electronic communication, Mr. Martin Nelson will have electronic communication either through Facebook Messenger or some other electronic way to communicate with the children. He'll initiate the call. First, he will text Crystal Nelson, and then he'll make the call, and the two children, Ian and Luke, will be able to talk to their father uninterrupted. Will be on Tuesdays, Thursdays, and Saturdays from 6 p.m. to 8 p.m. Central Standard Time. And I said I'm not ruling on travel to Japan at this time. However, I will order that the children get passports. Everybody should have a passport. So the way it'll work is Mr. Nelson needs to sign what's called a consent form. You can get that consent form. Are you writing this down, Mr. Nelson? Okay, so you go to the website. It's www.travel.state.gov. And it's called a consent form. And so you'll print out that original form. It has to be signed in front of a notary. You'll have to use some type of identification, if it's your driver's license or passport or some photo ID. And whatever you use to identify yourself to the notary, you have to make a copy of that. It has to be that same document. It has to be a photocopy, and that has to be used. And so, Mr. Nelson, you are to do that, print it out, sign it, copy the driver's license, whatever, get that to your attorney. And in order to get the passports for Ian and Luke, it'll cost $270. So you're also to get $270 to Miss Crystal Nelson. Then Crystal Nelson is ordered to get the passport photos, the birth certificates, the applications for passport, and you are to submit those to the district clerk's office in Austin County within 5 days of receiving this consent form from Mr. Nelson. I'm going to assume Mr. Nelson is going to do that fairly quickly. So again, she's ordered to submit all that information to the district clerk's office and get that passport process going. If it has not been submitted to the district clerk by August 1st, 2022, then Mr. Nelson's child support is suspended until Ms. Nelson actually receives the passports. And the way you're going to prove that you submitted that to the district clerk, Ms. Nelson, is there's two different forms of payment that have to be used to get a passport. One, it's $100 a piece to the State Department, and then $35 a piece to the district clerk for processing. So when you do that, you'll get a receipt from the district clerk for $70. And you will get a copy of that receipt to Mr. Nelson so he knows that that has been submitted.
What was the date on that, Judge? I'm sorry, August 1st?
Well, if she has not submitted the applications by August 1st, 2022, then Mr. Nelson's child support is suspended. So she essentially has a month to get this submitted.
No, that's fine, Judge. I just was trying to jot down the date.
Okay. Okay, both parties will enroll, sign up to Our Family Wizard, sign up for that by July 8th of this year. So Ms. Nelson is to have a geographic residence of Austin County with the kids. Again, as joint managing conservators, they'll consult on medical, psychological, educational. Atkins, anything else I need to talk about?
Your Honor, are you ordering long distance travel provisions for the
Well,
Texas Family Practice Manual?
In the temporary orders, the only long distance travel would be during those either 14 days in this summer, which he'll designate that time, or those long weekends, but that'll be within the continental United States.
Is the court ordering the exchange of the children at the airport?
No, either Mr. Nelson or Miss Murphy, pick up and return the children at Miss Nelson's residence.
Okay.
And again, I'm going to reconsider this when we come back for a final. This is just, hopefully this will be finalized here in the next 6 months or so.
All right. And Your Honor, you said that it was the rights and duties regarding medical, psychiatric, psychological, and education were supposed to be after consultation. Is that independent after a consultation, or is that subject to the agreement of?
Let's do it subject to the agreement.
Okay. Your Honor, I would ask the court, I'm going to show you my request for relief. This is, I believe, and my opposing counsel can correct me if I'm wrong, that the opposing party was okay with the rights and duties that as I have them listed in 1, 2, and 3. Am I incorrect, Mr. Anderson?
What we had said was that they would consult, and like in the Arizona order, after they've consulted, then since she's the only one here, that it would be like independent subject. But if the court wants subject to the agreement, then I mean, yeah, the tiebreaker is normally how it goes after that. So I mean, it's up to the court, whatever the court wants.
So I mean, the reality of it is for this educational and medical, the tiebreaker is going to be Crystal Nelson. So.
Okay.
Okay. All right.
All right, so Ms. Atkins, anything else?
Yes, I wanted to clarify. So currently for the possession and access, Your Honor, for my client, whether it's his mother exercising it or him, my client gets 14 days during the summer for 2022. Does he get any period? Is the court issuing at this time any periods of possession for summer for 2023? 3. I mean, I hope that we have a trial date before that, Your Honor, but I don't know what your trial schedule looks like,
Well, let's,
nor do I know what his deployment schedule looks like,
Right.
Your Honor. So I'm always hesitant with the military service members.
okay, so hopefully we're gonna have a final before that time. In case we don't, we'll just say that you'll have the time as set out in the family code where he has to designate by April 15th, and then he could get that time in the summer. But that would be
Okay.
2023.
Okay. SPO. Okay, and then he is, all of his periods of possession are supposed to be exercised within the continental United States, but he is allowed to have essentially extended periods of summer, excuse me. He's allowed to have weekend periods of possession. Specifically, he's allowed to have Labor Day, Memorial Day,
Martin Luther
Martin Luther
King.
King Day,
And
and he gets spring break and the Christmas holidays per the standard possession order.
yes,
And is the court changing that based off of whether or not, so if my client, hopefully, this is falls in the category of hopefully my client, we have a final order on this one, but if my client is stationed back into the United States before we get a final order, does that revert to a standard possession order in that situation?
yes.
All right. Sure, I don't have anything else, Your Honor. And you made a couple of references in here that there would need to be text messages sent to Ms. Nelson. Would that be messages through Our Family Wizard, not text messages?
And
If they're coming from
Is-
my client?
and this, my question is going to be is, and you can probably answer it better than I can. If he sends, I put down this text message stuff about telephone calls. So if he sends a message through Our Family Wizard and says he wants to call, talk to the boys here the next 15, 20 minutes, is there a way that Miss Nelson gets that message, or does she have to log into Our Family Wizard?
Your Honor, she should receive, if she sets the notifications for the Our Family Wizard app on her phone, she should receive a notification that she received an Our Family Wizard message, and she'd open it. My understanding is it works the same way as a text message. She'd have to click on the app, just like you'd have to click on your text message app in
All right.
order to be able to read that message.
So that it can just all be through Our Family Wizard.
Okay,
And, and we can, just in case there's no question that, see today, I don't know, Mr. Nelson, are you going to try to talk to the boys tonight?
that would mean that you have to call the children and
Within
starting within
about
the
an
next
hour.
hour 15, yeah.
I'm going to be going into work,
Okay,
so I won't be able to.
all right, so then Thursday would be the next time, Thursday, June 30th would be the next time between 6 and 8 Central Standard Time.
Your Honor, the reason why I was saying Friday was because I don't have because of the time schedule during the time that I would be calling the boys, I would be at work.
Is there, what's the time on Thursdays that you can make calls?
About 5:30 in the morning for me, which would be 5:30, 15:30 in the afternoon.
So 3:30 here?
3:30 there.
Okay, so I'll tell you what, I'll change this a little bit. So this is just gonna be during the summer. So until school starts, then the calls on Tuesdays and Thursdays be from 3:30 to 5:30 Central Standard Time. And on Saturdays, it'll stay the 6 to 8.
And does he still have the ability to, but it's 6 to 8 during the school year, correct? Still for Tuesdays and Thursdays?
And Saturdays during the school year, yes.
Judge, we can try to figure out how to make this work. I just want to let the court know that one of the boys goes to Creative Care Learning Center. Is that correct? Yeah. And from 3:30 to 5, while my client's at work, of course. However, we can try and figure out a way to make it work. Maybe we can, if one of the boys has a phone, maybe we can get it to the learning center where when he calls, they just make the child available at the learning center.
Okay.
I'll have to try and get creative.
Let's see if that'll work with the Learning Center.
Okay, if not, I'll get back with Miss Atkins.
And that was part of the reason why we wanted the Fridays, Your Honor, because that's when the children aren't in any type of facility and my client is in fact available.
Okay. All right, well, for now, in the temporary orders, again, Tuesdays and Thursdays from 3:30 to 5:30, Saturdays from 6 to 8 Central Time. All right. Anything else, Mr. Anderson?
No, Judge, am I free to leave?
Nobody has any more questions, then you're all excused.
My only question, Your Honor, is if we were going to get a trial date, is the court aware of what their next available trial dates look like?
Yeah, I'm not. We need to get with my coordinator is Maria. And it would, the earliest is, I hate even to see the fall is probably out. So we're probably into early 2023 at this point. How long do you would anticipate a trial taking?
Your Honor, at this point, I think it would be safe to assume 2 days would be just on the safe side, Your Honor. I don't want to underestimate as far as a trial date, at least a full day, maybe a day and a half.
Well, we've used a full day here on temporary orders, so.
That's what I'm saying.
I think if it was in person, it might be 2 days. If I can get with opposing counsel and we can work out a time when maybe Mr. Nelson will be back in the U.S., maybe we can formulate a game plan to do it at that point. But we'll work diligently trying to agree on a date.
And I'll get with Maria and have her start looking for a couple days. But like I say, it'll probably be the spring or the early part of 2023.
Thank you, Judge.
All right, thank you, Your Honor.
Thank you. You're all excused.